Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Arizona Green Party versus Bennett, 20F, Supp, 3D, 740, District Court, D, Arizona, 2014. Friends, the topic of the day is ballot access, like it is on a number of these other podcasts. So let us advance ballot access for third parties today. Anybody out there from Arizona? Today we're talking about the Arizona Green Party. I've never even been to Arizona. It sounds nice. I'd like to go there. I've never been there. So what happened in this case, friends? What happened? It says, quote, Plaintiffs Arizona Green Party and Claudia Elquist filed a complaint against Arizona Secretary of State Ken Bennett challenging the constitutionality of an Arizona election statute. Document 1. The parties filed cross motions for summary judgment, documents 15 and 17, and orally argued their motions on May 7, 2014. End quote. First of all, good job, Arizona Green Party, for challenging this. A lot of people don't want to go to court, from what I hear, so the fact you did so, it says something. It says a lot. Way to go, friends. It also says, quote, Plaintiffs want the Green Party on the ballot for the 2014 election. As explained below, state election law requires the Green Party to have filed a new party petition by February 27, 2014, 180 days before the primary election. On February 25, 2014, plaintiffs sued the Secretary alleging that ARS Statute 16-803 mandating the February deadline is unconstitutional. Specifically, they argued the challenged statute represents a direct restraint on plaintiffs' political speech and severely burdens the political speech, political association rights, and voting rights of plaintiffs, in violation of the First and 14th Amendments of the United States Constitution and 42 U.S.C. Statute 1983. End quote. Once again, our friends are invoking the First and 14th Amendment. We can't praise those amendments enough. Here at Free Press Media Press Inc., we're dedicated to advancing the First Amendment and advancing third parties, so I love to see the two combined. And then, the 14th Amendment is cool too. So way to go. What do you think about this? Do you think 180 days is enough? What do you think the deadline should be for filing ballot access petitions? Should it be more? Should it be less? What do you think? What do you think the judges here felt about this? Do you think they felt persuaded? They first note that the reason the 180-day deadline is in place is because of they say, quote, the 180-day deadline is tied to the primary election, end quote. So what do you think about that? Do you think it should be? Do you think that's a good reason to have it? Our friends at the Arizona Green Party had some good arguments. So let's read what they said here. They argued the following, quote, they would not be able to collect sufficient signatures by February 27, 2014. Petition requirements are so onerous for third parties such as the Arizona Green Party that they must begin each campaign to regain ballot status immediately following the conclusion of the previous election cycle. The February deadline can greatly increase the cost of minor parties incur collecting the required signatures for their qualifying petitions. The February deadline is not designed to allow a reasonably diligent minor party organization to qualify for ballot access, requiring minority political parties to gather signatures on their petitions so early when the mind of the general public and the attention of the media is not focused on the general elections is unduly burdensome, end quote. I like these reasons. Indeed, if, according to them, you're going to get ballot access signatures, it's going to be a perpetual thing. You're going to always be doing it. And we wouldn't want that. there's other stuff to be done. And we don't want to incur extra expenses. And also, they do have a good point. We hear about people getting burned out from elections. If you have to gather signatures right after the election, that's going to cause people to feel more burned out, and they might not respond favorably. Unfortunately, the judges here said they provided no evidence of these assertions. Alas, alas. These judges like evidence. So, when we have ballot access trials in the future, let us be certain to get evidence so we can give them what they want. Of course, that's not going to guarantee any success, but it can help us advance. The Green Party here did the best they could, so we applaud them. Now let's take it to the next level. They did, however, see some validity in the argument about the long processes of getting signatures before election. Unfortunately, although they think there's some good reason for that, they don't buy it because they said our friends didn't provide any evidence. They did say the Secretary of State did offer evidence, which persuaded them. Alas, alas, we had good arguments here. Ultimately, they conclude this. Especially if other deadlines and requirements are assumed constitutional, and given the state's uncontroverted evidence concerning the interplay between the February deadline and its election scheme as a whole, ARS Statute 16-803 rationally accommodates the state's administrative needs, end quote. And then they say, quote, it is therefore ordered denying plaintiff's motion for summary judgment, document 17. It is further ordered granting defendant's motion for summary judgment, document 15. The clerk shall enter judgment in favor of the defendant, and that plaintiffs take nothing, end quote. We're not going to take nothing from this. We're going to take inspiration. Our friends at the Arizona Green Party did a good thing. They didn't win, but they did a good thing, and we can take that for inspiration. So, good job, Arizona Green Party. Let us be inspired to do great things for ballot access. Long live third parties. Goodbye.